All right, we're live.
Happy Thursday. We're back again.
Yeah, happy Thursday. I'm Julie Lebenz. This is Billy Tarasio. We are Arizona lawyers, and we go live every week on Thursday. And we talk about all sorts of different issues related to Arizona family law. And today we're going to be talking about the most important statute in Arizona's child custody laws, which is the best interest standards. It's kind of a weird statute. There's a lot to it, but it comes up in almost every custody case. So we're going to talk about it today. Billy, how are you doing?
Doing great. Doing great. As you know, it's been a crazy week. Crazy week. But things are good, and I've been prepping for a huge trial, and the custody factors are front and center. So I'm glad that we're talking about it.
Awesome.
How are things going with Win Without Law School?
Win Without Law School is going really well. This week we're talking about disclosure. We're getting into failure to disclose. Next week we're going to get into some discovery stuff. And then today, after our live, I'll be talking about trial skills, and in particular cross-examination, which is really difficult if you have no background or training in it. And I've seen so many self-represented parties completely fail at cross-examination, even though they had some really good material that they could have gotten into if they just had a little help. So I'll be talking about that today. But yeah, it's been going really well. You know, a sense of community is really growing. There was one particular participant who had something come up and couldn't make it this week and sent an email to let me know, like, you know, they're really into being a part of the group. So want to let me know why they weren't there. And then just, you know, helping people through various questions they have. A question that came up was, how do I amend a pleading? And it's actually not that difficult if you know the rules. There's some really nuances about the rules that you need to pay attention to, but you know, explain that. It was really simple. The 20 days hadn't passed, could just do a simple amendment. And then to the extreme of, you know, somebody had an order protection hearing, and we talked about some ins and outs of what to expect at the hearing. And so I'm curious to see how that went. But
well, they posted about it on our Facebook group and said that Win Without Law School was one of the best things they've ever done, and it totally worked, and it was dismissed, and she was so happy. So yeah, so well done, changing lives, access to justice. I love it.
Amazing. We were actually, I should have connected with her yesterday, but my computer decided to do an hour-long update when we were supposed to go live. So I was an hour late. So I wasn't able to connect with her yesterday, but I'm sure I'll see her today. So, oh, that's so exciting. I love that.
Yeah, it is exciting. So for those of you who are new, Julie and I are going to go over our topic du jour, which is the best interest statute and how you can present your custody case. It's super important. We're talking about this from an Arizona law perspective, and everything we're giving you is information, not advice, not the substitute for meeting with either of us as your attorney. You can do that. You can contact Julie's office in Sedona or my office in Phoenix, and we're happy to have that conversation with you and give you legal advice. But this is really for those of you who either are represented already, or you just want to know, or you're helping somebody through this, or you're representing yourself. So today's topic is best interest. You can send in questions, and the second half of our hour will be spent just answering your questions. You can ask those either on TikTok Live or over through the Facebook group, Decode Your Divorce Arizona Support Group. And as always, if you're looking for more information, or on YouTube, we're also live on YouTube, so you can ask questions there too. And if you're looking for more information, this is what you like, and you need more of this, then definitely check out Win Without Law School for way more of this information. So Julie.
And really, one point I want to bring up, because this is so cool, is the gal that had success at the order protection hearing this week. She was up against a lawyer, and she won without law school.
Nice.
So that's really exciting. And she had an order of protection against her that she disagreed with. And so she requested a hearing, and she contested it, and she got it dismissed. So that's really exciting.
Yes, that is so exciting. Congratulations to her. And congratulations to you, Julie, because what we're doing at Win Without Law School is working.
Yeah, it's so exciting.
That is exciting because it's an experiment, right? The question is, can you teach people in a very short period of time the nuts and bolts of what they need to represent themselves successfully in court, where you are required to know all the rules? And of course, it's not all, you're not always going to win a case. I don't always win a case. You don't always win a case, but being able to be there and do a good job and know what you're talking about and develop a strategy and go in and represent yourself to your best of your ability is a huge win.
Present exhibits, testify. And, you know, she's paid maybe around $300 for Win Without Law School. And what do you think she would have paid a lawyer to defend her at that order protection hearing?
You know, if I'm going to estimate, I would guess about 3,000. I would guess about 3,000. What do you think?
I was thinking 2,500. So we're right in the same ballpark.
Yeah, I think maybe a legal paraprofessional could have done it for 1,500, maybe a lawyer for 3,000. And so we're talking 300 to 1,500 is 5 times. 300 to 3,000 is 10 times. So that's exciting.
Yeah. And she went, so that's awesome. And that was our vision, you know, for many years before we actually created this current, you know, iteration of what we're doing. This has been the vision, is to help people who can't afford a lawyer. I mean, obviously, if you can, that's the best way to go, because you don't have to go through all the stress and the learning curve and the risk. But not everybody has that $1,500, $2,000, $2,500, $3,000 to spend for one hearing. I mean, literally, that's for one hearing to get the order dismissed. So this is amazing. And we're so excited. If you would like to join or get more information, check out winwithoutlawschool.com. All right. So with that said, why don't we get into today's topic?
Yeah. So the statute on tap that we're going to talk about is 25403. It is the best interest statute. And here's why it's so important. A judge may not enter a child custody order or parenting time order or change a child custody or parenting time order without having an evidentiary hearing and considering each of these factors. That's a big deal.
It is. And the factors aren't very straightforward. It isn't necessarily things that you would think about to present evidence on. But sometimes, especially if you have two self-represented parties battling it out at a trial, the party that actually presents evidence pursuant to law could win, even if their evidence isn't as strong as the other side. So packaging your evidence pursuant to this statute could make or break your case.
Yeah, I totally agree. When you're doing a case, and we've talked about this before, I'm not sure what you called it, but I call it like paragraphing or chunking, where you want to let the judge know what it is you're talking about. So judge, I'm moving on to ask questions about blank, and then whatever it is. So we're going to talk about custody now, and I'm going to walk you through these factors. What's really nice about that is you're making the judge's job easier for them. They have to write down what you're saying and the evidence under these enumerated factors. So if you give it to them that way, it's easier for them to consume and digest.
Right. So if you're representing yourself and it's your turn to testify, right? So the judge turns to you, Billy, who would you like to call? Or Ms. Tarasio, who would you like to call for your next witness? Judge, I'd like to testify. So the judge will have you sworn in by the clerk, swear to tell the truth. You take the stand. Now, sometimes a judge will have you testify from your seat, you know, where you are at the counsel table. Other times they'll have you go into the witness box and testify. So you could just be flexible on that point, but then you're going to start testifying. And one thing you can do if you're representing yourself is you could print out the best interest standards. You can take that piece of paper up to the stand with you. If you get an objection from the other side, what's that paper? Just explain, judge, it's some notes so I can know what to testify about. I'm nervous. And that should be just fine. You're allowed to have some notes about your testimony, especially when you're representing yourself. If you have an attorney and you're being questioned, bringing the notes up isn't going to fly. But if you're representing yourself, it will. And so then you can just read down, okay, and this is where Billy called it paragraphing. I call it signposting. But this is where you can introduce what you're about to testify about. So, Judge, I'd like to talk about factor 1 of the best interest standards. which is the past, present, and future relationship between the child and each parent. And that's when you can start talking about it. And I like to break that first factor down. Okay, now I'm going to talk about the past relationship. All right, now I'd like to talk about the present relationship. Now I'd like to talk about the potential future relationship. And on this particular factor, the details are so important. Like, this is your opportunity to tell your story, give the judge, like really pull at the judge's heartstrings and talk about your relationship with your child or children over the entire course of their lives up until this point, and what you would like to have with them going forward, which can be really powerful. And a lot of people who are representing themselves really miss out on this opportunity because they don't give the details.
Right. So you want to talk about, Julie said the past, the present, the future. I usually do that as, when the two of you lived together, since this time of separation, moving forward, same thing. We're just talking about, what happened, in your timeline. And then you want stories like, well, here are the things that we really love to do together. Or, my kiddo, does really struggle in school, but one of the ways that we really bond, or that I support this child, is by working with him in his homework. And here's what that means. And he really feels most loved when I listen, or like when you talk about, your child's needs and how you meet them, and different ways that you connect with real examples, or one time we were doing blah, 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 or pictures. Sometimes parents will use pictures. I really like this, honestly, under the factor about homeschool and community. I like pictures, and I like just describing kids in their homeschool and community through pictures, but you want to be specific.
And if you're going to be very advanced, when you're thinking about this first factor, think about what the other side's contentions are against you. Like, what are they alleging? For example, if they're saying, you haven't participated in the child's life, this is your chance to explain how you have. I was there when my daughter was born. I was there when she took her first step, or whatever your story is. If the other side is saying you weren't there, this is your chance to explain how you were. Or if they're saying that you don't take the time with homework, you can explain how you're taking the time with homework. A lot of people just blindly think the judge is just going to know what to do, but the judge is not this all-seeing, all-knowing, person. Instead, you need to tell them, and that's what testimony is all about. And so, what's the story you want to tell? Because you can tell a story in a million different ways. So, what are you going to say that's not only compelling, but matches up with the best interest, and that refutes whatever allegations are being thrown at you in the trial?
I totally agree. Not every factor in the best interest statute is going to be applicable in every case or contested. Let's say everybody has a good relationship with the children, and that's not what we're fighting about. It's okay to then say, under that factor, mom and dad both have very strong relationships with the children and will continue to do so. If it's not a contested issue, move on. You don't have to fill up the space. So if the contested issue, let's say, is the mental and physical health of the parties, that might be the time, the place to really put a lot of your details. How do you handle that? Do you list every single factor in every single pretrial, or do you only list the ones that are relevant in the specific case?
I list every one, but if it doesn't apply, I'll explain, does not apply in this case. Mm-hmm. I like to do that just to be comprehensive and make it clear, my position on each issue. But you wouldn't necessarily have to do it that way. But I think your point is valid. You don't need to create controversy where none exists. The court wants to hear where you're getting along and where you agree. Mm-hmm. And also, the court wants to hear that you're supportive of the other side as a parent. Right. And so, instead of just throwing mud the whole trial, you do have the opportunity to also praise the other parent, which can help show that, you really want what's best for the child.
It goes a long way. If you can find the positives and put them in there, you're going to be more credible. You're going to seem more objective. Like, there's a lot of wins in finding ways to praise the other parent in your pretrial statement or in your testimony.
Right, that don't take away from your case either.
Exactly.
Mhm. Now, one important factor is factor 6, and this comes up a lot if there's been domestic violence. So factor 6 explores this concept of which parent is most likely to make sure both parents have a really strong relationship with the children. So it's not worded exactly that way. It's about, which parent is most likely to encourage a meaningful relationship. The exact words are slipping my mind at the moment, but that's what it's about. However, there's a caveat. If one side can show that they denied parenting time in order to protect a child from witnessing child abuse or domestic violence or being a victim of either of those, then you can be justified in withholding the child and not encouraging the full meaningful relationship. So if that's a factor in your case where a child's been withheld, either you're the one that withheld the child or the child was withheld from you, this is going to be a really important factor to present a lot of evidence on from both sides.
Yeah, it is. It's a big one. And if there is domestic violence or there has been domestic violence, you also need to look at ARS 25403.03, which is the specific statute on domestic violence. I want you to put those factors in your pretrial and in your testimony as well. They're very important. And in fact, if domestic violence is alleged, the judge has to make specific findings on those factors as well. It's not optional, even in a temporary orders hearing. So make sure that you put those in as well.
Now, an interesting concept came up in Win Without Law School this week, which is the desire to take a reasonable position and figuring out what's reasonable within your case.
Yeah.
And so this particular mom was like, in her pleadings, giving dad more parenting time than she really wanted to, and more than she believed was best for the children because she didn't want to look unreasonable. And so we had a deep discussion about what is unreasonable in family law. And so what are your thoughts on that, Billy?
Oh man, I wish I knew. I wish there was some rule somewhere that says what's reasonable and what isn't. There isn't. So it depends on your judge. And I think the point you're bringing up happens for a lot of people. They know they have to appear reasonable. They know they have to appear like they're supporting the relationship. How do you balance that with what you think is best for your specific child? I would love to hear your thoughts or what you told the person.
Yeah, so a couple of points. When we look at reasonableness, a lot of that comes down to attorney's fees, because the statute for attorney's fees talks about financial resources and reasonableness of positions. And in the case law on that, it talks about, look, it's not just about taking different positions. It's okay if you disagree, but is your position not grounded in law, not grounded in fact, driven by emotion? That probably isn't the best definition, but not grounded in law or fact. And so there's that aspect. But then there's also this technique of requesting alternative relief. So one thing you could do is take the position you want. Look, I only want dad to have parenting time 1 weekend a month, no overnights for this schedule. Alternatively, judge, if you think that's too restrictive, then how about with overnights or every other weekend or whatever? Then go to the original position you were going to request with a bit more. But now you're showing the judge, look, this is why I want the more extreme position. But if you don't think that's just, here's the other position. And now the judge is like, wow, you've really thought this through, instead of, oh, you're just crazy and you're trying to deny dad of time.
I really like that. I really like that point very much. And also being able to articulate exactly why you have proposed the parenting plan you've proposed. If you can, and I suggest on custody cases, not just to go through the best interest factors, but also to prepare a proposed parenting plan that is super comprehensive and to walk through the judge why it is that you're proposing this particular plan. And if you can articulate why you've asked for exchanges to happen in this way, in this time, why you're asking for expenses to be paid in this manner, why you're asking for a certain way to have exchanges reimbursed, or the money reimbursed based on XYZ that's happened in the past, the more logical and thought out and comprehensive your argument, the less likely you can possibly be unreasonable.
And that's where creating your trial outline is so key, because if you don't have this all teed up and planned out before you go into the trial, it's going to be really difficult to keep track of everything and remember all the points you want to make and
Yes.
call up the right exhibit. And
right.
really, it takes a lot of planning. Okay, first I'm going to talk about legal decision making. And these are my exhibits for legal decision making. And these are the factors and the best interest standards I'm going to talk about. Okay, now parenting time. Here's my proposed parenting plan. This is one of my exhibits. Here's the best interest standards about parenting time that I want to talk about. And here's other exhibits, or, here's a set of text messages I want to exchange, or I want to present, or here's a police report I want to present. You've really got to have it ready to go. Otherwise, you may not get your evidence in because you could forget about whatever exhibits you have or points you want to make. So it's really important to be organized and have it organized within those best interest standards. Because like Billy said, the judge is going to be filling that information in on their computer or on some form they've got at their desk. And so if you can just help them along with each of the standards with your positions, that's great. I had a mentor in the law, and he used to always say, whichever side makes it easiest for the judge wins, which isn't necessarily true, but there is some truth to that. That, if you can just lay it all out and make it simple, the judge will get your side and possibly rule in your favor.
Right. Yes, they have a huge workload, not a lot of time, which is why we talk about themes, why we talk about theories, why Julie teaches how to do your direct examination. I think you should practice. Don't go to court without practicing. Practice using your exhibits, practice testifying, record yourself using something like Zoom, listen to yourself back. Do you like the way you sound? Have you hit all of so first practice it with your exhibits, then listen to it as if you're the judge. And if you have to make the findings, and then you'll see, did I hit it all? Did I get everything in? These are important cases, really, really important cases. You can't really be over prepared or spend too much time on this.
Yeah, and let's talk some more about some of the factors. There's factor 2, which is about the interrelationship between the child and other people in the child's life. So this is where you can talk about relationships to grandparents or aunts and uncles or stepchildren,
right,
or teachers or anybody else in the child's life that's important. And this can be really big in a relocation case, for example, to show the child's ties to relationships here and how you want those to continue.
Absolutely. Non-common siblings. This would be a good time to talk about that. Step parents. So you can use this either way. If your child really struggles with their step parent or their step sibling, this is where you would want to really hammer that, how this is detrimental to their best interest and why, or how strong it is.
Yeah. And that brings up a good point. Like, you could write out all of your gripes, so to speak, all of your problems with the other parent and their parenting time, how it's affecting the child. And then look at the best interest standards. Okay, where do each of these issues fit within the standards?
Exactly. Everything you wish you could say, where do I put it? How do I tie it into the evidence or to the factors? That's exactly the way that you want to do it. So
there's factor 2 about interrelationships with various people. And then there's another factor about adjustment to home, school, and community. So you have a chance to not only talk about relationships beyond just, with the parents, but also about how's the child doing in school? What are the community ties? Are they in sports? Is that important? All sorts of things about homeschool and community. Also, if you have issues with the other parent's home, what type of living situation they're providing for the child. This would be a chance to provide testimony or pictures. And again, Billy mentioned this earlier on this factor. this could be really great to present photos or awards or, anything that is gives the judge even more of the story. Just talking about is one thing, but seeing a picture, seeing the child's room, seeing the award, seeing the child playing sports, whatever it is, gives the judge a different insight than just the story.
Yeah. And this works on offense and on defense. If you're on defense and they're saying that, the child doesn't like you or doesn't have a great bond with you, pictures of you guys on vacation, pictures of you guys doing activities together, pictures of them with their cousins at your house that you took or at birthday parties, that's going to really be good. That's going to undermine any argument that you are somehow disengaged or uninvolved. I think that's some of the strongest evidence to combat those allegations.
Now, there's another factor about what the child wants.
Yeah.
And what do you think about that factor? Because it's not so clear cut, what's the age of the child? How do you get that evidence out?
I mean, so it really depends on the case, right? We have to figure out what is going on in the case. And it also says if they're of suitable age and maturity, but you can kind of ignore that. You're allowed to write down what it is you think. So you're allowed to say, my child really enjoys the routine and thrives on the routine that happens at my house. When they come back from the other house, they don't have that. They've expressed how anxious or stressed out they might feel. Their wish would be to continue in a structured routine that suits their individual needs. You can say that. You can say, I don't think that there's really anything that's off limits here. Stories are helpful though. Stories are very helpful. So, I am working on a relocation case and, the mom did, wishes upon a star for, New Year's. Instead of doing New Year's resolutions, she and their kids wrote down wishes on a star. And dad lives out of state and wants the kids to live out of state. Mom wants the kids to live in state. And the kids had written down on the star, that daddy would move back home. And that's super helpful because it indicates they don't want to go live there. They want dad to come back home. That's evidence of their wishes. So it's a great way for the judge to understand you didn't ask them, you're not interviewing them, but they view their home as here.
Yeah. Sometimes I'll have clients who'll say, well, I can't say that, it's hearsay. And it's like, well, look, just testify. You can draw an objection. It can be dealt with. In general, hearsay is allowed in most cases anyways for family court.
Hearsay is allowed. Hearsay is allowed. Children can't testify. A factor is the wishes of the children. It's going to get in.
So you can testify. And like Billy said, it's going to be much more compelling if you have a story or something and not just like, oh yeah, Johnny said he wants to live with me.
Right.
Like,
don't do that.
It's just, that doesn't really help the judge.
No.
But talking about, look, Johnny's expressed to me he'd like to live with me. Plus, I can tell he's thriving in the routine we have. He's very close with the dog we have, or, he has this special playground in the backyard and he spends a lot of time out there, or whatever it is that, the child thrives in. Give those examples, because otherwise you're not giving the judge any real evidence to work with.
Right. Right. And of course, this is such an interesting factor because some judges really care, some judges not as much. It's very interesting with teenagers. Obviously there's this huge cultural preference to have children be, equal time. And you might have teenagers that really don't want to do that. They really don't want to do that. And they may not want to see the other parent. And that gets real tricky. It is really, really hard, next to impossible, to have a judge order no parenting time to one party. So when you've got teens, you got to really think about how to structure that parenting plan and how to present that argument. Probably want to convince your teen whenever possible to at least spend some weekends with the non-preferred parent. I don't know. What do you think about those cases?
So last year, there was a bill that went through the legislature that would have changed this
Yeah.
statute to
Yeah.
actually give the child's preferences total priority. And
Presumptive. Yeah, presumptive
from my
priority.
point of view, thank goodness that didn't pass, because children can be manipulative. I think it's way too much pressure to put on a child to have to decide that. So I don't think it would be a good change in the law. And there was a lot of objections within the family law community to this. But instead, what we have is we don't have any presumptions, but what the child wants is one factor, which I think is the right balance. Let's consider what the child wants. And of course, everything around that. Is it really what the child wants? Is the child of suitable age and maturity? Is there something else motivating this child to say they want to be with one parent? But ultimately, I agree, Billy, it's going to depend on your judge as to how much weight they're going to give that factor. And you do, under the law, have the option of requesting what's called an in-camera interview, where the child can meet with the judge in chambers. It's a recorded conversation, but the judge can essentially talk directly to the child. I have had those granted very rarely in my career. A lot of judges are not interested in doing an in-camera interview. One case in particular where I had, it was a huge game changer in my client's favor. The child went in and actually badmouthed my client, but the judge saw right through it. Was like, this child is way too young to be saying things like this. She's clearly been coached, and the whole thing flipped in our favor. So you never know what's going to happen. But there is that option if you feel like the child has something really special that the judge needs to hear directly about. You can request it, but it may or may not be granted depending on your judge.
So here's a tricky question. If you are asking the judge to meet with a child, the child has now become your witness. Do you as a lawyer meet with that child?
I do not, no.
Yeah, I haven't either. And this came up in my office and I advised against it. But in order to properly advise your client on whether or not it's a good idea, you kind of need to understand how that child presents. So I don't know, I'm grappling with that a little bit as we talk about it.
It's a tough one, but most of the time the judge is going to deny it, so it won't come to fruition. But yeah, that it is an option. Yeah. So it's there. The other side may request it.
Most of the time in Maricopa County, Conciliation Services does the interview.
Oh, okay.
And gives a report to the judge. So you've got a lot of layers there of removal, which might be good in some cases, might be bad in some cases. We have some questions. We have not gotten through all the factors. This first question is a pretty good one. How do you defend reactive abuse? And I'll take this a step further. I want to talk about that. So significant domestic violence. So if the judge finds significant domestic violence, there's a presumption against joint custody or sole custody to that parent that perpetrated significant domestic violence. Now, many times a judge will punt, or an evaluator will punt and say both parents have committed acts of domestic violence, therefore neither gets preference. So let's talk about that type of situation and what she's describing as reactive abuse.
Can you define reactive abuse?
Yeah, so it's when, you've got an abusive relationship. Let's say dad is controlling and dominating and manipulative, and mom throws a water bottle at it. Or, dad does the very typical, I'm not abusive, she's crazy, she's abusive. Look at when she did blah, 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 blah. And people will basically describe when they snap and they start screaming or they start acting like, a little nuts as reactive abuse.
So I think if you're facing this situation where the presumptions are out the window because there's a finding that both sides have engaged in some act of domestic violence, I think you really need to get clear about your objectives, because the domestic violence presumptions are very strong regarding legal decision making. And so is legal decision-making in dispute in your case? If it's not, because for some families, education, healthcare, religious training, and personal care just aren't disputed. For some families, the kids go to the school they're going to go to. The kids don't have any health issues. They're going to the same doctors they've gone to. Religion isn't an issue for most parents, and personal care decisions people just figure out. So in some situations, those exact issues aren't in dispute. And even if the parents have a hard time communicating, you can potentially set up, okay, look, we're only going to talk via text, or we're only going to exchange this sort of information. Like, you can put some parameters on communication. On the other hand, if you have a big dispute over one of those areas and you really want SOL, can there be a workaround? Could there be an agreement reached that we have joint, but I have final decision making if we can't agree on education? Or we have joint on everything else, but I get SOL on education. Can you have a workaround, or can that be a reasonable position to take with the court? Look, judge, I see that you've concluded we both engaged in domestic violence, but we still need to resolve our educational disputes. So can I have final decision making? So can you, despite all of the domestic violence stuff, instead of getting caught in arguing about what happened 2 years ago in the house when you guys had a horrible fight that was absolutely horrendous and it's even traumatic for you to relive it, can that be put aside? And instead we can focus on how are we going to resolve decision making in a way that's best for our children. And then parenting time. If you have concerns that the other side is not safe with the children, there's some sort of abuse, verbal, physical, emotional, then you need to start gathering that evidence. Because if you're not going to get the presumptions under the domestic violence statute, that doesn't mean you're out of luck. You can still prove, you can still get some restrictions placed on parenting time based on evidence you're presenting, whether or not you get the domestic violence presumption.
I agree. And I'm working with a domestic violence expert in a case regarding coercive control. And I've become, here's my current thinking on this. Significant domestic violence is not, it depends on if you are a domestic violence victim. So if you are a domestic violence victim, you probably have suffered some post-traumatic stress. You probably have suffered some depression. There is probably an ongoing pattern and a dynamic of abuse and control, authority and domination. That pattern is what makes the co-parenting relationship toxic and dangerous for children. And that is when the presumption should kick in. Issues of fighting between parents that is not the result of a abuser, a primary abuser and a primary victim. A healthy couple that is normally has a fair power balance that has this horrible fight where they both, act out against one another is not a contraindication to co-parenting. But the dynamic that exists between a dominant abuser and a victim that has played out over time is contraindicated for joint legal decision-making, because the dominant person will use any decision and any mechanism and any tool they can to dominate the other party. So I think, and this is just a try, that's how maybe you try to present your argument and present why joint legal decision-making would be contraindicated in your case, and treat decision-making and parenting time differently, just like Julie said. I don't know if it's going to work. That's just what I'm going to try.
Yeah, and just because the domestic violence presumptions may or may not kick in doesn't mean you don't have other evidence to present that can still change the outcome.
Right.
So certainly, yes, if you can get those presumptions to apply, that makes your case stronger. But if the judge doesn't go for it for whatever reason, still present your other evidence, still make your case.
Next question. What if a GAL is biased or not conducting investigations for over 6 months?
I would imagine you could file a motion with the court asking the court And maybe there were some deadlines put in place. I'd look back at the order appointing and see what the deadlines were. Maybe there aren't any deadlines that have passed, but if there have, then you could bring it to the judge's attention and try to get things moving forward. You could start with an initial notice to, what was it, a JAL saying, hey, look, you know, this was the deadline in the order. It looks like you haven't complied. What's the deal? I'm going to bring this to the court's attention by Friday if you don't respond. Anytime you can resolve something without getting the court involved, that's your best bet. A lot of people think, oh, I'm going to tell the judge and this is going to be great, but really it takes time, you know, and the judges are busy. So the more you can resolve outside of court, the better. But ultimately the court's there to help you if you aren't successful resolving it on your own. Biasness, though, I mean, that's a tough one.
It's a tough
She
one.
mentioned biasness as well, and I'm not sure.
Yep.
I mean, you can potentially, if there's certain things that you think they're being biased on, you could ask to have a conversation with them about those things. I can't guarantee that's going to be effective or not. I don't know exactly what the things are or who this person is, but you know, if this person's going to take the stand and testify, this would be some good information to get before they testify. You know,
Yep.
Where are they coming from on these points so you can craft effective cross-examination questions.
Exactly. You are allowed to depose court-appointed experts. You are allowed to depose them. You're allowed to subpoena their file. And you may be able to prove bias. You may be able to prove that they didn't do what they needed to do. So there are requirements that these court-appointed experts have. There are best practice standards and requirements that they have to follow. And if you can show it didn't happen, you're going to be able to discredit the report. So if the report is highly detrimental to you, that might be something to consider.
One other thing too is analyzing, is it best to challenge the issue or comply?
Right.
So if you think they're being biased, for example, because they don't like the way your house looks, they think your house is dirty, do you want to clean it up or do you want to challenge that they're biased? Like, I think you really need to analyze, what do you think the biasness is? And are you going to get further with honey or vinegar?
Right.
Can you know, conform at least for the time being and do what this person wants and change what's in their report? Or do you want to try to prove biasness, which may be an uphill battle?
I think that's an excellent point. Like, what is the path of least resistance, and stay focused on your goal. Never do anything based on principle. Only do something if it's going to be effective in helping you achieve your goal, because your goal is not to make friends or have the GAL like you. Your goal is whatever your goal is. So in the house example, that's a great one. Like, just clean up the house, invite them back out, have them redo the report. Boom, good to go. Okay. How do I approach emergency custody if there's already an order in place?
Well, do you have irreparable harm?
Immediate and irreparable harm. Is there an issue that presents to your child immediate and irreparable harm? That is the only way you even qualify to ask for an emergency custody change.
And keep in mind that when you get an emergency order, it's good for about 10 days. It can be extended for longer, but there's going to be what's called a return hearing set, and it's supposed to be set within 10 days, or again, it could be longer for good cause. But at the return hearing, your emergency order expires. Now, again, it can be extended, but this is what the law is getting at, is the law wants you to show something that's hot, that's happening right now, and there needs to be immediate action in order to protect yourself or a child or property.
Right.
Now,
you're violating due process. You're getting a judge's order without the other party having an ability to be heard, which is a basic violation of our individual due process rights. And there is a time and a place where you need that, and it's justified, and that's the immediate and irreparable harm.
And so an alternative is, if you can't meet that standard, is you can request expedited relief. Now, if you're requesting expedited relief, you still need to explain why. You can't just be like, well, I want to be heard soon. No, you need to explain why this needs to be handled as soon as possible. And never forget the potential opportunity of trying to resolve things with the other side, even if things are crazy. Look, hey, you just got a DUI and you're in jail. Can we agree that I have custody? Whatever the issue is, and especially if the other side's down and out, can you reach out and be like, hey, can we just agree to this instead of me running to the court? And or can we sign the stipulated order for temporary custody or whatever it is? Don't forget, you have an opportunity to get this done directly. You don't always have to go through the court. Now, you do want the court to sign off on your agreed upon terms. You don't want it to just be an oral agreement between the two of you. You do want to get it formalized as a court order. And we talk about how to do that in Win Without Law School. But don't forget that you can potentially get this done on your own without having to file all the papers and prepare for court and go talk to the judge and get a court order and prepare for a return hearing and all of that stuff. And what an opportunity for co-parenting. Even if you've had a horrendous history, if some emergency comes up,
Right.
Can you finally work together in the best interest of your child in the face of this emergency?
Yep. And depending on what's going on, sometimes your child's needs are super specific. And I've got a situation where there's a little boy with some severely challenging behavioral health issues, really challenging. And the parents are high conflict, but in no universe can the family court handle these issues better than these parents. It's just not possible. It's too complex. It's too unique. And really, if all of us looked at our families a little bit more that way, a little bit more like, but this is, a judge won't get it. They won't get it. They won't understand the unique dynamics that exist in your family. And so if there's a way that you guys can work with a really good counselor or really good mediator to help get everybody pointed in the same direction. Ultimately, most parents love their children, and you just have to remind them to love their children more than they dislike their ex, which can be hard. Next question. When do I submit my evidence if I'm the respondent petitioning for modification? I have court in a few weeks and my lawyer has not filed any of our evidence.
All right, so you'll want to look through the court orders, in particular, the order that set your hearing date, and see what it says as far as an exhibit deadline, a disclosure deadline. And when you're saying submit, what do you mean by that? Everything needs to be disclosed. So has it been disclosed, which means exchanged with the other side? That's not filed with the court. And then as far as submitting to the court, there's an exhibit deadline that you submit your exhibits prior to a trial. In Yavapai County, it's 5 business days prior to the trial. So you just have to see what it is for your particular hearing, your particular county, and then that's when it gets filed. So I would look at that order, and then you can see whether or not you've missed any deadlines or anything like that. I would imagine your lawyer will be on top of those deadlines because that's very, common in every case, and we're all trained to comply with those deadlines. And we usually, for exhibits, I'm usually filing mine on the day they're due or the day before. It's generally not anything I'm filing way ahead of time. So it would be normal for those not to have been submitted yet if, for example, the exhibit deadline's March 1st.
Yes. And I just want to distinguish between choosing your evidence, selecting your evidence, and submitting it to the court. Courts do not look at exhibits until they are admitted at trial. They are not read or reviewed in advance. And I don't think that most people really understand that. Your evidence has to be admitted through a specific process. The other side has the ability to object to the admission of your evidence. And only at that point, usually after a trial, does a judge look at evidence. How do I prove financial abuse? He's dragging the court case out with multiple hearings, and I'm a full-time student.
Okay, so financial abuse, normally I would think of that in the context of a divorce and property waste, but it doesn't sound like that's what the question is. The question is more about resources for the litigation. Now, if you have an attorney, you can request that the other side be ordered to pay legal fees if they have more resources than you, and or if they've been unreasonable during the case, if they've extended things unreasonably. But if you have not incurred legal fees, if you haven't hired a lawyer, then the court may say, well, look, you don't have any legal fees or costs. So your remedy is not clear here. I don't know. What are your thoughts, Billy?
I mean, financial abuse is not in any statute anywhere. So it is well recognized on the domestic violence wheel of ways that you can be abusive, but that has not been codified into Arizona law in any family law statute. So it's not something you need to prove. There's no benefit to proving it because it's not in the statutes. You would have to, you have to prove things that are relevant. So unreasonable conduct is relevant. Let's say that they're asking for hearings without any basis or not giving you documents you need. Those we have remedies for. Financial abuse, we don't. And I'm not saying it's not real. It is. It's just not in front of the court. They're confined to making decisions under the rules of procedure and the statutes regarding family law.
Now, one argument you could potentially make, and this may not be successful, but let's say the other side, the questioner is talking about the case dragging out and essentially it costing her money as a result. And so one thing that could be compelling is if you could create an exhibit that shows all the days you had to miss work because of the various court hearings and how much money you ended up having to forfeit because of that. And then if you can make the argument that these hearings were unnecessary and explain why, that could be compelling. Now, is that legal fees and costs, damages, like would the court really grant anything? I don't know, but it sounds like that's what you're getting at. And yeah, you could potentially present that evidence. I'm not sure whether or not the court would grant the relief you're requesting, but your point could be made and you may get some relief out of it because the court may say, well, those are some costs that you incurred because of legal stuff, and the court may throw you a bone on it. I don't know.
If there's joint legal decision making with one parent having final say, how do you enforce a good faith effort when it's never followed by the parent that has final say? So the parent who has final say is just doing whatever they want. What can they do?
Well, you have a potential enforcement action brewing. So this is where you'll need to document each time a potential decision's coming up where you're not being consulted and they're just making the decision. Now, this is going to be the most compelling for any decisions where you had something to say or some point to make that you think could have influenced the final decision. Because if it's something where you're already in agreement, then yes, they still should have consulted with you, but the court would likely just be like, well, it's moot. You guys agreed anyways, so who cares? So it's really going to be more on those issues where you feel like you disagreed and that your contribution would have mattered and you can potentially enforce it. But, at the end of the day, I'd be really looking at this in a practical sense of, do I really disagree and why? Would it have made a difference? Is it really important to our children? And then maybe looking for a workaround to get involved more or to get the information first, because the court isn't necessarily going to have a great remedy for you on this one.
Yeah, it's a tough situation. Are you allowed to bring exhibits to cross-examine someone if they weren't filed or previously submitted? Okay, exhibits don't get filed. So I'm just putting that out there. They never get filed, but let's say previously submitted.
In an order of protection hearing, yes, there's no requirement to exchange exhibits ahead of time. So at an order of protection hearing, yeah, you can come in with exhibits you've never shown to the other side. Now, when you do, I would have 3 copies, one for you, one for the court, and one for the other side for the hearing. But outside of the order of protection context, no. If you're in a regular divorce case, custody establishment, there's all sorts of disclosure rules. in a post-decree matter, the disclosure rules are a little more lax. The deadlines are closer to the hearing, but there still are deadlines and requirements to disclose ahead of time. If it was something you just discovered, for example, the night before, then it would be newly discovered. You could try to get it in again. Make sure you have a copy for you, a copy for the court, a copy for the other side, and be ready to explain how this is brand new and why it's relevant and why you want to present it now. But if it's something that you've had for 6 months and now you're trying to present it at trial, likely not going to work.
Yeah, the only exception would be, let's say you read their pretrial statement and they're accusing you of being a big fat liar about XYZ, and you've got evidence that XYZ is true. That's called a rebuttal exhibit. Maybe you didn't you didn't get it in earlier because you didn't know you needed to, but now that you need to defend yourself, you want to submit this rebuttal exhibit. You don't need to wait until trial. You need to disclose it as soon as you can and put the other side on notice. This is a rebuttal exhibit based on what I read in the pretrial, and then get it to the court as soon as possible. That should get in. But also try to put in your pretrial statement a little line for any rebuttal exhibits. I don't know that that helps. I don't know. What do you think, Julie?
Yeah, definitely. You always want to add that.
I do it. I don't know. I don't know if it makes a difference, but I do it. Okay. What's the process if the other party has a drinking problem and refuses to get help? And then it says comma with a teen. So I don't know if the teen has a drinking problem or if the teen is the child at issue and the parent has a drinking problem. I'm just not sure.
Let's talk about in the context of the parent with the drinking problem, because I think that we'll be able to talk more about it from that angle. So a couple of things, do you have custody papers in place or not? If you do, looking at what the terms are and kind of thinking, okay, what changes could be made to address the drinking issue regarding our current parenting plan, no overnights or only time during the day when they're not drinking, what could potentially happen there? Or do we need to look at SoberLink or, some other ways to keep track of sobriety during parenting time? So if you already have a parenting time in place, how could it be modified to protect the child from the other parent's drinking? If you don't have a plan in place, then you're looking at, what do I want to create? What could we create for a parenting plan that's going to keep the child safe and potentially utilizing some of these tools, the breathalyzer, which is called SoberLink, no overnights, only visits in a park. I mean, you really have to see how this person drinks and all of that. You're going to have to tailor it to your specific situation, but I wouldn't go straight for the supervision route because a private supervisor is very expensive. Who are you going to find that wants to sit and monitor somebody's parenting time? Who do you trust to do that? So I wouldn't just be like, oh, her parenting time can be supervised, because it's really not a solution. So I'd more be looking at, okay, what can we do that's non-supervision, a non-supervised option to make sure the children are safe. It's unlikely you're going to get zero parenting time unless it's just super extreme alcoholism, kids in the car, DUIs. I mean, it's possible no parenting time, but most likely it's going to be restricted somehow.
Mm-hmm. Well, Julie, you've got to get going to
I do.
Win Without Law School classes today on disclosure, discovery, compliance, sanctions. I love it. If anybody is interested in learning more from Julie, definitely go to winwithoutlawschool.com and register to get more information there. Great to see you. We'll be back next week.
Bye, Billy.
Bye.